You've worked for 30 years. You built a business, paid off the house, accumulated real assets. You sat down with an attorney at some point, maybe 10 years ago. You signed a stack of documents and felt like you were done. Here's a question nobody asked you after that meeting. Is what you signed actually protecting what you built, or just check a box? I can't tell you how many times I've had clients who've come in, some very wealthy, who would bring down a stack of documents that they proudly would say, "Here's my estate plan." And I'd say, "What's in it?" They said, I have no idea." And some of the estate plans were built well for 10 years ago, but it didn't keep up with, um, their current life. So, I've established this episode for successful families in Florida with over $2 million in assets, or business owners that may be approaching liquidity event or succession, retirees who review their plan once and haven't revisited, or anyone whose estate plan was drafted before any sort of major life change. When people come in with their estate plan, it's the family after a loved one passed away, and they proudly bring in the trust that mom or dad did. They said, "Mom and dad put it all together. We have this wonderful trust, and so therefore we don't have to go through probate." So I ask, "Okay, well, that's great, but let me see what's in the trust." They said, "Well, how do we know that?" And that's when I asked for deeds or maybe financial statements that show who owns the trust. And so sometimes it will be the individual who passed away instead of their name of the trust. Unfortunately, I have to at that point tell them, "Well, I'm sorry, they did a great job drafting the estate plan. They did a great job of, considering where they want the assets to go, to whom, when. Um, but they didn't take the extra step of funding the trust, which means retitling the assets into the trust. So unfortunately, they still had to go through probate. Beneficiary designations on retirement accounts or life insurance, that could override what is in the estate plan. So sometimes that's very disjointed, and it can sometimes lead to some inequity in the eyes of the beneficiaries, because the estate plan says one thing, but the designated beneficiaries say something quite different. Um, Outdated trustees, healthcare surrogates, powers of attorney. They may be deceased, they may be estranged, or unsuitable at this point. A lot of times people say, "Oh my God, what were we thinking? Why did we have Joe and Angela in there? That makes no sense. Why do we do that?" And the problem was, if something had happened, the people that they're now estranged from would have the power to make decisions for them. And so sometimes we need to review those as well. Um, Homestead rules, how they interact with the estate plan. Homestead is very tricky in Florida. There's specific rules and the Florida Constitution that directs how the homestead can be distributed once you pass away. So that's a trap for then where that we often see. And also plans drafted in another state. They haven't been reviewed under Florida law. We have some different laws like the homestead and elective share. Um, so I've been doing this for over 25 years for our county. I hold a LLM in taxation, which means a master's of law in taxation. And we are a boutique firm. We deal with estate planning, real estate, probate, asset protection. So things that are very, very closely tied together in a legal sense. So that is what we specialize in. We don't do litigation. We don't do criminal law. We don't do family law. We specialize in estate planning and probate and real estate and asset protection and tax planning when it comes to people's legacy. So, what we've learned over my 25 years is that every family that walks in the door has worked hard to build their legacy. Um, And it's very concerning to me when they don't keep up with their documents or assets aren't titled correctly, because then at that point, everything that they built, their legacy, isn't passing the way they want it to. So that is what we try to address with our clients through sort of a three-step process. So we start by mapping out everything. What are the assets? How's it titled? What are beneficiary designations? What existing documents you have? What's happening in family dynamics? And what are their goals? Okay. So family dynamics is a tough one sometimes because of the fact that the client has to be very open and honest with me to talk about what they're concerned about with their children, whether or not one of them has a substance abuse problem or special needs, or they may just be concerned that with divorce rates being very high, that their children's marriage may not last, and therefore they're very concerned that they don't want their assets to go to a future ex-in-law. Um, but also having a real conversation about, are they good with money? Are you satisfied with their work ethic and their choice in occupations, things like that. So it's having a conversation in a very comprehensive way. And how does that fit in their estate plan? How does that fit in their goals? Um, Whether or not they have charitable intentions, that's another big factor that we have to take into account when we're determining what the full picture is. And then also, if they do have existing documents, it's what are they actually saying? And does that reflect what is their current life? And see if it still meets their goals. So once we do the review and we have talked to the client and have determine what their estate planning goals are, we then design a coordinated plan. How is it going to be structured? What is the trust structure? Titling, tax positioning, incapacity planning. That works together rather than uh, at cross purposes. Okay. So it may be that we're creating a trust an irrevocable trust to address the estate tax issue. Maybe they have more than $30 million in assets, or their assets are growing at a very rapid pace and they can see themselves getting past the unified credit, which is currently 15 million for an individual and $30 million for a married couple. At that point, they may want to create different structures to take advantage of the current laws to be able to pass millions of dollars to their children without any sort of estate tax. It could be maximize the step up in basis. So public forum means that anybody can come in and fight. So we've had it where people come, where we open the probate process and one of the children does not like how they're being treated. Um, and so therefore they file some sort of complaint or petition to slow up the process because they feel that's not fair. So what that does is that delays things. It sometimes requires the personal representative or the family to go against the decedent's wishes just to, it becomes an economic decision of it's cheaper to settle this out of court rather than continue to pay the attorneys to fight, to go through this just to prove this wrong. So that can sometimes lead to the decedent's wishes not being followed because of that. Or if a plan is very ambiguous, that can sometimes lead to families fighting as well. Unintended heirs. So with 23andMe or Ancestry.com, I've had a lot more clients come forward who have, at 65 years old, all of a sudden find out that they have a 40-year-old child. And so under the intestacy laws in Florida, which means when you don't have an estate plan, those unknown children have a right to the assets because at that point they're legal heirs. Um, and so that was if you don't address that in the estate plan, then that potential could happen, or it could be an ex-spouse. of a child where, again, you do not want the potential ex-spouse of a child to be able to gain your assets that you meant to leave to your child. Or it could be a creditor of that child. They have problems with creditors, and you pass away and that money passes to them, or that creditor that is there to kind of swipe up that asset to satisfy, their judgment or whatever it is.